Hello and welcome to episode 21 of The Legal Scoop, our webinar series here at LOMAD, where we talk about recent wins that our attorneys or our staff have had in the past month and try and give you guys some pointers based on these wins. I'm Brennan Shannon. I'm an associate here at LOMAD. I'm joined today by my colleague, Brian Prince, who's a partner here at LOMAD. So why don't you say hello, Brian?
Hello, Brian.
So Brian had, I believe, two interrelated wins involving schedule loss of use and applying the contralateral extremity or limbs range of motion when calculating schedule loss of use. So if you wouldn't mind, Brian, could you just give us some background on the case or cases that we're discussing today?
Sure. First one, easiest one, it's a knee case. And so claimant had, like a mild loss of motion in the knee, had chondromalacia, and so his doctor found a 20% schedule for it. Adjuster, sent it over to me and was like, hey, take a look at this. Let me know if you think we should accept this, deny me, what's going on. So I take a look at it, and the first thing I noticed is that, okay, they assessed the left knee, but they didn't even measure the right knee. So immediately, red flag in the play. And then I went back and I was kind of questioning, is this chondromalacia related? Is it not related? Who knows? And so we went and got an IME. And I was under the impression the IME was going to say, there's some decrease in motion, but the chondromalacia is not related, like 7.5%, 10% schedule. It found a 7.5% schedule, but for literally the opposite reason. Because our doctor measured the contralateral knee, found both knees to have full extension and 125 degrees of flexion, so there's no difference. And so found 0 for loss of motion. And then with the chondromalacia, which is, between mild and marked chondromalacia is 7.5 to 10%. And it's only based on 2 factors. 1, if there's atrophy on exam, and 2 is range of motion. And so with 0 range of motion deficits and no atrophy, he awarded the 7.5% schedule at the lower end. And I'm like, great, awesome. So we go to the hearing and claimant's pro se, and I argue for 7.5% because the claimant's doctor's an idiot, did a bad exam, and the judge decides to set it down for testimony. So we didn't depose, we took at hearings testimony of the 2 doctors, and man, the judge really didn't want to do it, but he awarded the 7.5% schedule because there was, no legitimate basis for the claimant's opinion, no cause-related loss of motion, and 7.5 low end of the chondromalacia is the appropriate finding. So
right. So for those of you watching at home, what's at play here is that when, under the guidelines, when we have schedule loss of use, as long as, so say someone injures their right shoulder, as long as the claimant didn't suffer a previous accident or injury or have some issue with their left shoulder, the doctor has to record the range of motion of the left shoulder in addition to the established right shoulder. And then you compare the two to get the range of motion deficit of the right shoulder. So what I mean by that is, say normal range of motion, overhead range of motion of the shoulder is 180 degrees. If the uninjured left shoulder's range of motion is, say, 160 degrees, that's considered their full range of motion. You then take the range of motion deficit for the established right shoulder, say it's 140 degrees, and you have a 20-degree deficit in range of motion as opposed to a 40-degree deficit, which would result in a lower SLU, or as Brian pointed out when we were talking about this beforehand, sometimes it results in no schedule loss of use. If, say, they have 160 degrees on the right side and 160 degrees on the left side, there's no loss of range of motion. And the only reason there was a schedule loss of use percentage at all here is because, like Brian said, there was a special consideration that applied for chondromalacia patella, which resulted in 7.5%. Now, I understand, Brian, that you also are filing a rebuttal on a similar issue that's sort of brought something up that's somewhat interrelated. Is that correct?
Correct. This one is a shoulder issue, and claimant's counsel is challenging not only the appropriateness of using the contralateral shoulder, which there's case law which says it's presumed you're supposed to, try to use old range of motion measurements for the shoulder, despite the fact that the reason we use the contralateral at permanency is because there might be other issues, age-related non-work degeneration, body habitus, stuff like that, which would affect both shoulders. And they also tried to challenge me on my math, which is where they really ran into some bad times because they didn't cite any support for their position. Now, admittedly, there are 2 different schools of thought on how to take the contralateral into consideration. The one that we like is obviously the one that results in lower schedules, and actually measuring the difference from the uninjured contralateral, like you said, per section 1.33b of the guidelines, and not just because there's case law that says that any opinion on permanency has to be consistent with the guidelines. The method outlined in the board's FAQ, which I don't know who thought up it, but they're clearly not good at math, results in really perverse outcomes. So in the shoulder example, if the injured and uninjured shoulder each have 90 degrees of abduction, they're at their baseline. Zero difference. Should be no schedule, right? But because 90 degrees is half range of motion in the uninjured, and it would otherwise be a 40% schedule, the board's FAQ would award them over a year's worth of benefits for being at their baseline. And that can't possibly be right, because we have a number of cases that say, hey, they're equal, 0% schedule. And I don't think all those cases are decided incorrectly. So I decided to cite all of them compared to the 0 claimants counsel cited. So let's hope.
Not on our watch. Well, these are great wins to discuss, Brian. I think very informative to our clients. And for anyone watching, I think it's just important to not take a schedule loss of use opinion, whether it be from the treating doctor or even our own IME doctor, at face value. It's always good to have someone look at it to get an idea of, like, did the doctor, follow the proper procedures here and submit an opinion that's actually accurate under the guidelines? Because it happens more often than you might think that the doctors make a mistake. Yeah,
because on that point, on the rebuttal, the doctors agreed 27.5%, and we got the judge to implement a 16.44% Schedule E arm, which is a huge difference.
Right. Yeah, and there's case law, Brian, right, that says the the schedule loss of use needs to be calculated under the proper application of the guidelines, and you'll see cases where, like Brian said, the doctors agree to something higher, and then we'll argue that it's actually something lower, and the board will implement something lower based on what the guidelines actually dictate. So yeah, definitely important not to take schedule loss of use at face value, or just to automatically stipulate to a split or anything like that, because very frequently one or both doctors submitted opinions that are wrong. So that's all for today. That wraps up episode 21 of the Legal Scoop. We'll be back next month to talk about more wins, and I'm excited to see what they'll be. Thank you to Brian for joining me today. And if you're interested in subscribing to our content, if you're on YouTube, you can subscribe below. We have lots of great videos, such as the Daily Grind with Melanie Daly. You can also reach out to go to our website to get access to our newsletter, which is also filled with a lot of useful and interesting information about workers' comp in New York State. Thank you.
Take care.